Welcome back. I am attorney Nicholas Hicks, and this is part 5 of 5 in the series of surviving criminal charges. This information I am providing you today is for informational purposes only. It is not intended to be legal advice. You should consult with an attorney licensed to practice in New York State to see how this information might apply to your particular circumstances. Now, the last time that we left off, we were talking about automobile stops and the particular inherent dangers in being stopped by law enforcement in traffic as concerns possession of different things that might be in the automobile, etc. Today I want to wrap up by talking to you about plea bargaining and trials. A plea bargain is a situation where a person accused of a crime is given an opportunity, if you want to use that word, sometimes it's an opportunity, sometimes it's not, to plead guilty, usually to something less than what the person is originally charged with, and or is given some kind of sentencing consideration from a court in exchange for their guilty plea short of trial. Now, you should know that the majority of cases in this country are resolved through plea bargains. Probably, if I had to venture a guess, 80% or better. And people plead guilty for a number of reasons, and sometimes a combination of reasons. There are people who plead guilty who are in fact not guilty. And one might say, well, why would an innocent person plead guilty to something they didn't do? And the answer typically is either they don't want to take the chance of being convicted after trial and facing a more serious sentence, or they may unfortunately not have the money or the wherewithal to finance a trial, and there may be other considerations. But you should know that, of course, if you enter a plea of guilty, from a legal perspective, you are guilty. In a court, if you were ever in trouble again, or you're applying for a job, or other kind of collateral situations that result from being convicted of a crime, in the eyes of the law, you're guilty. If you say you are, you are. So you must understand that. Because you don't get a chance to look back or explain and say, well, I said I was guilty, but I really wasn't. In the eyes of the law, you said you're guilty, so you must understand that. Now, there are other circumstances that you should be aware of when deciding to take a guilty plea or enter a guilty plea. There are other collateral consequences. For example, there can be deportation issues, immigration consequences. If a person is not a citizen of this country, a conviction could result in your being expelled from the country, essentially. And I've seen circumstances or have been involved in cases where had that occurred, for example, my client may have been sent back to a country where he may have been born, but has not been there since childhood, has no family there, they're all here, and would have essentially been in a place where he knew no one. So again, if you have immigration issues, you're not a citizen, that's something to consider. There can be housing consequences. If you live in public housing, for example, a lot of those leases have clauses that essentially, if you are convicted of a certain offenses, it could result in your being evicted. Of course, there's employment consequences. There are a whole host of consequences that can result from a conviction, and these are things that you should discuss with your lawyer before deciding whether to accept a plea offer or not. Now, the other thing that occurs often is I'll get calls from people who say, I want to expunge my record, my conviction in New York. Can you help me with that? And unfortunately, in New York State, if you are convicted of a crime, that is a misdemeanor or felony, and you were convicted as an adult, there is no such thing as expungement in the state of New York. It's a lifelong conviction, no exceptions. If you're an adult and you were convicted as an adult, it's a lifelong record. Now, I read a while back that there are some proposals about changing that, and I hope that happens for a lot of people's sake. But as it stands today, it's a lifelong conviction. There is something known as a certificate of relief from civil disabilities that, if that's granted, does not expunge the conviction, but can remove certain barriers to things like voting, holding certain licenses, or holding public office, other impediments that might be in your way with respect to certain employment, etc. So that's something to talk to your lawyer about. But outside of that, there's no expungement. Now, if you qualify for what is known as youthful offender status, that can replace a conviction. So in other words, if you have a young person who is at least the age of 16 but less than 19 at the time that the offense is committed, if it's a misdemeanor offense, first misdemeanor offense, then it's mandatory that a judge grant them youthful offender status, which means that even though they were convicted of that offense, the youthful offender replaces the conviction and protects that young person from having an adult criminal record. If it's a felony, then it's discretionary. A judge may grant youthful offender status but doesn't have to. Or if it's multiple misdemeanors, again, it can be discretionary, not mandatory. Aside from the youthful offender piece of it, again, as an adult, a conviction is a lifelong conviction in the state of New York. So that's something to be aware of. Now, if a person decides not to take a plea offer, assuming one is made, then of course, in most cases, the only other way a case gets resolved is by proceeding to trial. And there's many things to consider when considering trial. There's hazards, of course, in it. But there can be benefits, because the obvious one, if you win or you're convicted of something less than what you're charged with, of course all those things has benefits. But the first issue becomes, do you want a jury trial or a non-jury trial? If you are charged with a Class A misdemeanor or higher, that is a misdemeanor or any of the felonies, then you are entitled to a trial by jury. On the other hand, you can, if you choose, have the judge act as both judge and jury. We refer to that as non-jury trials. There are advantages and disadvantages to both of those decisions. That's something you should talk to your lawyer about. It is your decision as the client, your sole decision, but it's certainly something that you should discuss and get the input of from your lawyer. Now, in all instances, whether you go jury or non-jury, there are certain things you should know with respect to conduct, how you should conduct yourself during trial. First of all, we talked about dress earlier. Even if you're incarcerated, if there's any way your family or friends can get street clothes to you, a suit or a shirt with a collar, pants, etc., that's important, because a jury in New York is not allowed to know that you're incarcerated during trial. So you certainly don't want to clue them in that you're incarcerated by how you're dressed, which is usually that orange outfit they put on you, or some other bright color. So if you can camouflage that by having regular clothes on, that's very helpful, because of course, when you're dressed like an inmate, subconsciously you may be signaling to that jury that you're dangerous because they won't let you get out on bail, or you're dangerous because you look like an inmate. All these things count. The other thing to remember is just your demeanor, your presence. In most cases, I will have my client have a pad, pen, and they write. Write whatever you want, but just write. Whether it's writing me notes, whether it's writing yourself notes, making comments, drawing boxes, it doesn't matter. The key is that when you're writing, at least in my opinion, it makes you look more intelligent. And subconsciously, a jury might feel that a person who can read and write and who's intelligent and is participating in their own defense, intelligent people aren't dangerous people. Now, there's no truth to any of that, of course. But again, stereotypes. Stereotypes can weigh in, and you have to be aware of all these things. You got to be aware of how people think. The other thing that it does, and why I have clients write on a pad doing trial and doing hearings as well, is that it masks their expressions on their face easier. So if someone's testifying against my client, they're saying all kinds of horrible things, well, naturally, when we are, as human beings, when we feel like we're being attacked, it's natural to grimace or make a certain kind of face or to shake your head or react to what you're hearing. Well, if you're facing down at a pad and you're writing, it sort of hides your face from that jury because the last thing you want to look like to a jury, especially if you're accused of some dangerous offense, is to look angry or to look dangerous or to look bothered or anything. Because even though it's a natural reaction, a jury could misinterpret that as part of your personality and who you are. Because again, they're looking at you constantly during the trial. Even when they're not making direct eye contact with you, they're sneaking looks at you constantly, trying to determine in their minds who you are. And because they don't really know who you are, all they have to go by is what you look like and what people are saying about you on that witness stand. So what you look like and how you conduct yourself is extremely important during a trial. The other thing to remember too during a trial, and I tell my clients this all the time, when you are on trial 24 hours a day. So that doesn't mean just conduct yourself accordingly when you're in the courtroom. But for example, if you're out on bail and the court breaks for lunch or other breaks, well, you may stay, for example, here in the downtown area, and you may be somewhere eating downtown and making comments out loud about your trial or the facts of the case or anything. And unbeknownst to you, there's a juror 3 tables away from you that you didn't notice. Or if you're picking a jury, it might be a prospective juror from the jury pool that you don't know about. And they may overhear you or see you acting a particular kind of way and form an opinion about you. They may get on that jury. They may be selected without you knowing. Or they may already be on the jury and you didn't notice. That could hurt you because they may never tell you. They're not going to mention that perhaps until they get in the back room to deliberate with other jurors. And they're going to tell that, their fellow jurors, I heard him say X, Y, and Z. You never know. And we don't get to go in the jury room with the jury, so we don't know what they're talking about or what they're saying or what's influencing them. So it's very important to remember to conduct yourself accordingly. And it's very important, I think, for lawyers to instruct their clients with respect to how to conduct themselves during a jury trial. Now, finally, sentencing, if you're convicted. Although I suppose all judges will tell you that they will not punish you for exercising your right to go to trial. In my humble opinion, 20 years of law practice, I think that you do get punished if you lose a trial for practical reasons. If you, for example, were facing a 3.5 year to 15-year sentencing range, and you were promised 3.5 years on your plea, it's not unreasonable to think that if you lose trial, you might get 5 years or 6 years or 7 years. Well, why? Well, I think because the message that is sent is we can't try every single case. We just don't have the capacity to try every case. And if the public learned that you would get the same sentence after a trial as you would before a trial, why wouldn't you, if you're assuming you can afford to go to trial or you have a free lawyer, you try everything? Because you literally would have nothing to lose. You could win. And if you lose, you're going to get the same 3.5 years that you were going to get at the plea stage. So I think for those reasons, the message is you can go to trial, you can exercise your rights, but if you lose, you're going to get punished on some level for that. So these are just my practical observations. It's just my opinion. I don't speak for anybody else. But these are things that you should be aware of at trial. Again, thank you for joining me. I am Attorney Nicholas Hicks. This has been part 5 of 5 of surviving criminal charges. I hope you've enjoyed it. Go on to our YouTube channel, subscribe, like, and share if you think that the information is useful. Thank you, and I will see you soon. Take care.